These are appeals in the matter of Retirement Savings and Welfare Fund of Oil Industry Workers and Crescent Gas Corporation Limited and another.
Yes. Please, my lords, my lady, by way of introduction, may I introduce the parties?
You may.
There are many. I represent the Retirement Saving and Welfare Fund of Oil Industry Workers, the second appellant in the appeals, and the second defendant below. I appear with my learned friends, Mr. Hitchens and Mr. Kaner, who sit behind me.
Yeah.
We are instructed by Blackstone Solicitors. And to my left, my learned friends, Mr. Thankey, King's Counsel, and Mr. Mumford, King's Counsel, who appear together with Miss Newton and Mr. Kinman on behalf of the oil company. They are instructed by Eversetts Sutherland. To my right are Mr. McQuater, King's Counsel, Mr. Dewan, King's Counsel, Mr. Ballant, King's Counsel in that order, and behind them Professor Davies, Mr. Krishlinen and Mr. Farhan, who appear for Crescent. 5 of those individuals appeared below, sorry, 4 of those individuals appeared below. We're also grateful to Opus for hosting the bundles and transcribing the appeal. I suspect the transcribers will be grateful for a mid-morning and mid-afternoon break, although clearly...
I've got something that doesn't yet have transcript on screen. So I don't know whether that's...
No, I'm afraid I can't explain that, my lord.
It's just got the sort of, it's got a kind of home page.
Pause for a moment while I try and resolve that.
How do we start? Yeah. Right, thank you. Thank you very much. Obviously, Mr. Grant, we've Constitution has read all the skeletons. We're slightly disturbed by the extent to which there's repetition between the first and second appellants in terms of argument, and we certainly don't expect there to be repetition in this court. So presumably between you, you've agreed who's going to argue which points.
We have, my lord.
And is there a timetable, because we haven't seen one?
There isn't. It's partly dependent upon the order of submissions, and perhaps I can deal with that first.
Yes.
The parties have canvassed the idea as to whether the appellant should go first on everything, or whether they should just go first on the grounds of appeal, with Mr. McQuater and his team to follow on everything and the respondent's notice. There's a slight disagreement or difference of views between the parties on that. The appellant's preference is that the appellants go first on everything, on the basis that there's considerable overlap between the grounds of appeal and some of the respondents' notices, and it will save at least one round of submissions. Crescent's position is they would prefer just the grounds of appeal first, then they respond to that and open on the respondent's notice. It's really a matter for the court as to which the court thinks is going to be more useful to it.
About that, and you're not going to get to a respondent's notice before the first break, I don't suppose. So
no.
Okay, well we'll consider that point.
Sorry, can I just mention that I didn't realise I had a screen until just now, but I've now opened it up and it doesn't show anything. Can someone fix my screen as well?
Oh, I'm so sorry, my lord. As I understand it, so the tall screens are the ones which the Opus controller will bring up at the request of counsel or indeed the court.
I've said this
Yes.
many times now, and I repeat it, and I'm not going to get shirty with Opus because this is the sort of Rolls-Royce bit of it when we've got the evidence on screen. But really, the parties must ensure that Opus 2, if they're engaged, have come into court before the beginning of the day and have made sure that every judge's screen is running for the transcript. Not something that this poor lady has to do during the course of the hearing, but it's done beforehand. There's a sort of management lackadaisical attitude that's come up in a number of cases in the recent past where I've had to effectively express concerns, putting it mildly. So could you please ensure for the future that Opus are told, if they are instructed, the system has to be working and prove to be working before the hearing starts?
My lord, all I can do is apologise and we'll relay those comments back.
Okay,
can I ask,
right, off we go.
while we're at it, whether my lady has, the screen is working? Good. On that point, I see that at least 2 members of the court also have hard copies.
Yeah.
When I refer to documents, I will give both the opus reference and also the volume of the authorities bundle and the supplemental bundle, so that people can navigate as they see fit. That's fine. In terms of who else is in court, for what are hopefully obvious reasons, there is no one from the fund here from Tehran. I suspect of the oil company, but people obviously are free to watch on the live transcript as best as they can.
Okay.
Yes. What I propose to do is to open briefly some of the factual background and take you to specific bits of the judgment and then deal with ground 1.
Right.
That is my primary role in this appeal.
Yeah.
Then, subject to what the court decides and in mid-morning break, the plan is for Mr. Thankey to follow any other points on ground 1, ground 2 and ground 3. So irrespective of what the court decides, that will be what
The
happens.
ground 1 is obviously the overlap ground, which you need to deal with, so
Yes,
that's fine.
exactly.
Good.
My lord, before I turn to
Yeah.
does my lord or just Zacaroli still have a problem?
I'll manage for now. For now.
I can only repeat my apology for that. What I want to do before turning to ground 1, my lords and my lady, is set out briefly the factual background alongside the judge's key findings. This is context for the grounds. You can see to which parts of the judgment the grounds of appeal and indeed the respondent's notice relate. Start with my client, the fund. As is recorded in paragraph 9 of the judgment, the fund is one of the largest pension funds in Iran, with over 170,000 members, providing pensions for current and former employees of both private and public sector workers within the oil, gas and related sectors. It's not just limited to past and present employees of NIOC. There are other governmental and indeed private employers whose members or employees are members of the scheme. The history of the fund was considered in detail by the judge, and I just propose to make a few points. First of all, one can see from paragraph 32, in 1958, pensions regulations were implemented for NIOC, directing it to establish a segregated pension fund, open a specific account for those funds, and ensure that monies did not form part of NIOC's assets. 1964, a ministerial direction with force of law required the NIOC board of directors to act as amin of the fund's assets, referred to as pools of cash, which were not to be treated as part of NIOC's assets and funds. You can see that from paragraph 33. This was reflected in the successive iterations of NIOC's Articles of Association. See paragraph 34 of the judgment. I shall explain the Sharia concept of an amin in due course. Over the decades that followed, the fund became increasingly independent from NIOC. Ultimately, the judge found that NIOC only acquired independent legal personality in September 2019 when the Articles of Association were approved. That's paragraph 114 of the judgment and 165 to 176. The appellant's case is that the fund acquired independent legal personality in 2001, although that case was rejected. Convenient to mention briefly the existence of NAFT Trading and Technology Company.
Well, the case was not only rejected, you weren't given permission to appeal on it.
Well, rejected below.
And then Lord Justice Mayles refused permission to appeal.
Yes.
So you can run the case in your head, but so far as this court is concerned,
Yes.
the fund had no legal personality until the 20th of September.
I'm not seeking to run the case in my head, my lord. I'm just simply saying what the findings were. Started to deal with NAFT Trading and Technology Company, known as NTT. It's an English company incorporated in October 2009, a wholly owned subsidiary of the fund with a role in managing NIOC House. One can see that paragraph 21 of the judgment. The judge's factual findings in relation to the circumstances of the purchase of NIOC House were as follows. Starting at paragraph 43 of the judgment, the original background to the transfer was that on the 12th of September 1975, NIOC had purchased the property for approximately £7.5 million. NIOC was described as the purchaser and was registered as the proprietor with the land registry. NIOC had borrowed monies from the pools of cash of the fund to purchase NIOC House by way of a loan. Paragraph 47 of the judgment. Paragraphs 56 to 57, the judge also found that on the 13th the 15th of December 1979, the Board of Supervisors of NIOC expressed the view in a meeting that NIOC House was the property of the pension fund. However, NIOC had purchased NIOC House with its own monies, given that the fund did not yet have independent legal personality. It's 58 to 59. NIOC was therefore the absolute owner of NIOC House. However, NIOC and the fund may have perceived it. Paragraph 89 of the judgment. And therefore, the judge formed the view that the views expressed by the Board of Supervisors to the extent that the property was the property of the pension fund was a mistaken view, given that it reflected a view formed by the Board some 4 years after the purchase of NIOC House, without fully considering the legal impact of the fact that the purchase had been made by NIOC, with monies borrowed from the fund and belonging to NIOC. See paragraph 60. None of these findings is challenged by any of the parties on appeal, and the fund accepts that mistaken views were expressed and perpetuated over time by NIOC and the fund. However, the reality is as follows. The 1979 meeting reflects the genesis of a common long-held understanding by NIOC and the fund that NIOC was not the beneficial owner of NIOC House and that it belonged to the fund and or the members instead. Subsequent documents considered by the judge, which I shall address shortly, show a common continuing intention by NIOC and the fund, perpetuating this understanding and intending that it should be given legal and practical effect. The judge expressly accepted the fund's evidence at trial that this understanding was shared by the fund's professional advisors and solicitors. And I quote now from 25-26 of the judgment, "It was the commonly held view in NTT and of third parties such as Barclays Bank, who had a lease of NIOC House from NIOC, that the fund was the beneficial owner of NIOC House." In other words, this was the understanding held by all those involved with the property. In consequence of this understanding, over an extended period of time, NIOC House was developed, managed and administered by NTT, and the fund has invested millions of pounds in the development and renovation of the property. The fund has also received rent from NIOC House. As you will appreciate, NIOC and the retirement fund ran two alternatives case at trial, the first one based on Iranian law and the second based on English law. The Iranian law case was that the fund owned NIOC House as an absolute owner under an amanat of the assets administered by NIOC from 1975. The explanation of what an amanat is can be found in the judgment, paragraph 35. I don't propose to take you to it because it's academic for this appeal. The alternative English law case relied upon a number of documents said to be express declarations of trust, which postdated 2001. It's convenient to consider matters pre and post 25th September 2019, when the judge held that the fund did acquire legal personality. First of all, dealing with pre-2019 matters, the judge found that the reasonable person with knowledge of the background would conclude there to be 5 documents that would have amounted to pre-2019 declarations of trust in favour of the fund, but for its lack of legal personality at the time. The first was the resolution in Farsi of the Board of NIOC, dated 16th of August 2011, judgment paragraphs 180, 184, although the judge's view said it depended on the correct translation. The fund is happy to abide by Crescent's translation, which referred to the main owner. So that was a finding of a declaration of trust. Second point is paragraphs 182, 184 of the judgment. A letter from the Director of Legal Affairs of NIOC to Cathcart solicitors, 1st of February 2014. English solicitors instructed from time to time to advise the retirement fund. That letter instructed Cathcart to change the designation of ownership on the land register to record that NIOC holds NIOC House as custodian trustee for the fund. The third, fourth and fifth declarations of trust consist of the 3 letters from that firm of solicitors, Cathcart, to the land registry. 12th of November 2012, 11th of February 2014 and 18th of March 2014, paragraphs 183 to 184 of the judgment. They all state that NIOC holds NIOC House as custodian trustee for the fund. The fund found that on the basis that Cathcart were instructed by NIOC to make these statements, they were declarations of trust. So 5 declarations of trust found, only not effective because of the fact that the fund had no independent legal personality. Analysed through the prism of the 3 certainties of creating a trust, there was no certainty of objects, but certainty of intention, certainty of subject matter. As your lordship has already anticipated, permission to appeal has not been granted in relation to those pre-2019 declarations of trust. They're only relied upon as context for what happened and the subsequent findings. Moving on now to 2019, I turn to the judge's judgment at paragraphs 185 and following on the post-2019 declarations of trust. There were two. The first is at paragraph 185 of the judgment. This is the mortgage agreement between NIOC, the fund, and Bank Melli, dated 25th of September 2019, which said that the National Iranian Oil Company is the legal owner of the mortgage property, and the pension fund, saving and staff welfare of the oil industry is the sole beneficial owner of the mortgage property. This is referred to by the parties as the 2019 mortgage. Judge found this was executed by NIOC, acting by its attorney, NTT. See paragraph 186. The second post-2019 declaration was the certificate of title provided by Eversheds dated 9th of January 2020 as part of the same transaction. That stated for the purposes of clause 2.1.3.1 that, and I quote, the legal interest in the property is held by the company. The beneficial interest in the property is held by the beneficial owner. Companies
Am I
now
right in thinking that the case was not run by the respondents below, that if section 53(1)(b) was satisfied by signature by an agent, that NTT and Eversheds did not have authority as agents to sign the documents?
and that's certainly the fund's position.
It's
Yes.
not, that point simply wasn't run at all.
There's no challenge to the authority.
Have you got a page reference for that sentence that you highlight in, the judge highlights in 191, where we would find that in the bundle? I found the certificate of title, but not the relevant passage saying.
That's at the certificate is at. Shall I just give you the
44,
reference?
isn't it?
It's 44, page 339.
339
Yes.
disclosures 2.1.3.1.
Yeah.
It's at the end of the
339 of the supplement
certificate
bundle.
of title.
Yes.
Tab 44.
What's the actual page number of the bundle I find the reference to the beneficial ownership not being in NIOC.
Well, I was reading from paragraph 191 of the judgment.
Yes.
Yes.
SP
339.
44 339.
Yes, I'm grateful. Yes.
339.
It says disclosures.
Perhaps if we can call up supplemental bundle page 339, please.
Got it. Sorry. Yep. Found it.
Yes.
Thank you.
Thank you very much. Thank you, my own friend. If you're, I can move on. The judge's finding on the fund's English law trust case were as follows. First of all, the judge found that the reasonable person would conclude that NIOC had created a trust in favour of the fund by the two mortgage documents, which were a clear manifestation of an intention to create a trust. In other words, there was certainty of intention, subject matter and object. Sees that from paragraphs 188, 191, the judgment. Crescent seeks to challenge these findings in relation to the intention by way of Respondents' Notice 2.1. That's what 2.1 is geared towards. It's clear on common ground that the judge found that the two mortgage documents were in fact valid declarations of trust, putting aside the question of writing. Inherent in this are two further findings. First of all, that an agent is some person able to declare a trust a common law. Otherwise, the judge could not have found that the two mortgage documents were declarations. And secondly, and my lord has already anticipated this point, both NTT and Eversheds had authority and were legally capable of declaring a trust. Critically, the judge found that an agent was not, and I quote, some person who is able to declare a trust for the purposes of section 53(1)(b) of the 1925 Act. One sees that from paragraphs 194 to 200, which we'll look at closely in the context of ground one. in particular. That is the subject of ground 1 and ground 2. Moving on, paragraphs 201 to 213 of the judgment, the judge considered the consequence of non-compliance with section 53(1)(b). And the judge held that the consequences of non-compliance was unenforceability, such that the August transfer was not justifiable on the basis that the fund beneficially owned NIOC House and the appellants could not defeat the section 423 claim. This is the subject of NIOC's ground 3 and Crescent's respondent's notice point 1. There's a large amount of overlap between those 2 points. 213, there's a consequential finding that the August transfer was at an undervalue because of the fact that NIOC was the beneficial owner. And that is the subject of ground 7, which my learned friend Mr. Thanky, I understand, will be addressing the court on. Accordingly, the judge found at 213 that the August transfer was at an undervalue. Because of his findings that NIOC was the beneficial owner, the transfer could not be justified as a transfer to the fund. So those are the key findings and the various grounds raised by way of appeal and the respondent's notice. I simply wish to conclude on this point to say that as matters stand, there is an order for sale suspended pending the outcome of this appeal. And that's the current position. All parties, for admittedly different reasons, wish the matter to be resolved so that whoever turns out to have the ability to use the property and be the rightful owner can get on and own it.
Is that the property's in the process of being developed, isn't it?
It is, or at least it was, and the development has been heavily restricted by reason of the order.
There wasn't much going on, which is probably why.
Well, if your lordship is familiar with the building,
Well, I am familiar because
Yes.
I live about half a mile away from it. so-
well, you have the advantage in that respect. I have been to the property, if I can say that. At the moment, it's a glorified multi-storey car park.
Yeah.
I use no criticism by that. That's just a state of the reality. My lords, my lady, that's what I wish to say in relation to that, and now turn to ground 1. I may change glasses because that will enable me to read better and better help you. So ground 1, this is the question whether an agent can sign for the purpose of section 53(1)(b). By way of timings, it's now just a few minutes before 11, even allowing for a mid-morning break, if the court is willing to indulge that. I aim to finish by lunchtime.
Good. Well, it's a short point, isn't it, really?
It is, and it was a very short point below.
It's a short point on which the judge says there isn't really there certainly isn't any binding authority.
There's no binding authority, that's one of my points. If I summarise, you obviously clearly the court has our position, which is that on a proper construction of the provision, an agent can sign, and the judge was wrong to hold to the contrary. The judge's reasoning is brief. It hinges primarily on a comparison of paragraph 197 of the language of section 53(1)(b) on the one hand, and A and C on the other.
Yeah.
For reasons I'll come on to, that comparison is inapt, and the judge failed to start from the correct starting points. By way of overview, I make the following points. First of all, at common law, the starting point is that an agent can do anything a principal can. This includes declaring a trust. An agent's signature is the principal's signature. Second, the question then is whether section 53(1)(b), on a proper construction, derogates from the common law position. Third, as a matter of plain language, the fund's answer is no, it does not. An agent is, and I quote, some person who is able to declare a trust, so as to declare such trust. We say that that's an end to the inquiry, there being no binding authority for this court. In any event, the fourth point I make is that applying the relevant principles of statutory construction, the answer is also negative, having regard to, first of all, the purpose of section 53(1)(b), and its history and the comparison with A and C. And secondly, the undesirable consequences if an agent cannot sign. Pausing there, what I should have done some moments ago, but I'll take the opportunity to do so now, is to hand up a table which the fund has produced, which compares the statute of fraud provisions and section 53.
Yeah.
This was circulated to the parties yesterday morning. Whatever conclusions the court draws as to the help that can be drawn from the statute of frauds, I hope that this document is a helpful reference point when it comes to writing the judgment. I'll let the usher hand up copies to the court. Simply putting out in one column the provisions of the statute of frauds 1677, in the right-hand column the equivalent provisions in the Law of Property Act 1925. We've identified the precursors of sections 53, 1A, B and C, and indeed 2. We'll come on to that in due course unless anyone has any questions at the moment. I now turn to the applicable principles of statutory construction. I say this is a convenient place to start. Various principles have been set out in the fund skeleton, appeal skeleton, and in NIOC's appeal skeleton, and some other references to specific principles appear in other skeletons. There are 6 principles of interpretation upon which the fund relies now. I anticipate there'll be little opposition to the principles per se, although of course the application of them is doubtfully contested. Given the extent of the apparent agreement, I'll take this quickly. The principles are all to be found in Bennion. If I can ask Opus to call up Authority Bundle 152. For those preferring to use the hard copies, it's volume 5 of the Authorities Bundle.
You have to give me the page numbers. I'm working on the electronic bundle that was provided earlier.
It's within tab 152. It's
I have no tab numbers. I was already marking this up before that arrived, so you have to give me the page numbers, I'm afraid.
I will need to turn. We will do that, my lord. But I hadn't anticipated.
Electronic.
I'm sorry, Mr. My Ladies.
I think it's 3045 electronic.
I have that page. It appears to be Bennion.
Is this the beginning of chapter 10?
Yes. And I'm going to turn to specific provisions within it. I wanted to start actually with 11.1, which is within Opus pages 12 to 13. So that will be 11 pages further on for my Lord Justice Zacaroli. First proposition, one can see from 11.1, the paramount principle is the meaning of an enactment is the meaning that conveys the legislative intention, the primary indication of which is the legislative text. So a text even read in context and having regard to its purpose. So one sees that from paragraph 11.1, Bennion. That is an objective question by which the court must consider what Parliament is considered reasonably to have intended by the legislative wording under consideration. One can get that from 11.1 and also 10.9 of Bennion. Don't propose to take it there. The reference for that is within the bundles of the tab, pages 6 to 7. No. Second point is that the legislative text in its context includes context in its widest sense, to include the context of the Act read as a whole and its legal, social and historical context, subject to any rules as to the admissibility of external aids. In law, context is everything. One sees that Bennion 11.2, that's page 17 within this tab. Grateful of Opus can turn to page 17. One can see at the top 11.2. It's also enlarged 21.1 further on, but we don't need to go there for the moment. That explains the importance of context. The third point is that Parliament is assumed to be a rational, reasonable, informed legislature, pursuing a clear purpose in a coherent and principled manner. One can see that. We don't need to go back because we've already seen it. Bennion 11.1, page 12 within the tab. And within this third principle, the court should assess the likely consequences of adopting each construction, both to the parties in the case and for the law generally. If on balance, the consequences of a particular construction are more likely to be adverse than beneficial, this is a factor telling against that construction. And one can see that from Bennion 11.6, that's page 30 of this tab. You can turn to page 30, please. Yes, 11.6, the sideline bit towards the bottom of the page. As we explain in due course, our submission is that the judge's construction would have serious adverse consequences across a number of fields. The fourth principle is that an important point of the legal context is the principle that an act must be read and applied in the context of the law into which it is assimilated. Bennion 25.1, page 103, within the tab. My Lord Justice Zacaroli, it's internal page 827. I don't know if that helps in navigating to it. Yeah. And again, see 25.1, stating the proposition which I've just read out. The fifth point is a linked one. On the question of incorporating or attracting common law, an act may incorporate aspects of the common law expressly or by implication. And where an act uses a concept that has an established legal meaning, it will generally be interpreted in such a way as to have that meaning and to attract ancillary legal rules and principles. Move on to page 105, so 2 pages further on in this, Bennion 25.2 brackets 2. Now, I acknowledge this isn't an invariable position. The common law principle can be expressly disapplied. I say clear words are needed to achieve that. Sixthly and finally, on the question of having regard to legislative history, in order to understand the meaning and effect of a provision in an act, it is essential to take into account the state of the previous law. Bennion 24.5, so this is page 83 to 84 within this tab. My Lord Justice Zacaroli, it's internal page 752, 24.5. Yep. And we'll come in due course as to the help, if any, that the court can derive from the statute of frauds. These so-called principles, presumptions and canons, some of which may point in more than one direction, are presumptive aids only. That's what I wish to say about the law of statutory interpretation. Now we move on to the next point, which is the common law position. I say that consistent with some of those principles I've just set out, it's critical to appreciate the common law position relating to agents. The common law principle is that he who acts through another does the act himself. As used to be said, qui facit per alium facit per se. And I'm now going to turn to Boasted, and I'd be grateful for Opus if we can turn to Authorities Bundle, tab 159. And again, we'll, for my Lord Justice Zacaroli's benefit,
3208.
I'm extremely grateful, my lady. And the specific bits I rely on are paragraphs 2.018 to 2.019, which we found at page 9 within that tab. And if I can ask the court to read Article 6, the 2 paragraphs there, which are sidelined, 2.018 and 2.019. And of course, put stress on the words at the beginning of 2018, an agent may execute a deed or do any other act of the principle, save for the exceptions set out there. And the second sideline on that page makes the point that the fact that an agent and attorney can do all acts a principle can do is a, albeit weak, presumption in the construction of statutes. In support for the proposition set out in Bosted, Bosted cites, amongst others, the case of the Queen and the Justices of Kent, which I'd like to go to. This is Authority Bundle, tab 120. (2443), I'm told, my lord. Just pause and look at the first sideline at the top of the head note. The case was about notice of appeal to a court or quarter session shall be in writing, signed by the person or persons giving the same, or by his, her, or their attorney, or his, her, or their behalf. The question was whether a document signed by the clerk to the attorney came within that. The answer was it did. And if we move on, a couple of pages in the bundle, I think it's to, yes, exactly, page 3. We've sidelined it all, but I'm happy just to focus in on the short judgment of Miss Justice Quain, 2/3 of the way down the page. We ought not to restrict the common law rule unless the statute makes a personal signature indispensable. And I say that that principle, that approach holds true today. And there's no apparent challenge to this proposition by Crescent. Debate is simply as to whether section 53(1)(b) is one of the exceptional statutes which causes one to derogate from the common law position and makes, in the words of Ms. Justice Quain, a personal signature indispensable. There are other cases to this effect, a number of which are in the bundle. In the interest of time, I'm only going to take this court to one of them, which is a Court of Appeal decision of Northwood Solihull. It's Authorities Bundle, tab 88. 1856, my lord. If we start, so this was all to do with two documents signed relating to the Housing Act. If we can move to page 4 within the tab, please. So this is paragraph 1 of Lord Justice Lewison's judgment. Just ask the court to read that paragraph to understand the two documents in issue there. So two different documents, both signed by property manager. We can turn to page 10 within the tab. It's paragraph 22. Lord Justice Lewison sets out the general position of law, referring to a few other cases which are mentioned by the parties. It states the general rule. The person is treated as having signed a document if it's signed on his behalf and with his authority. Paragraph 24, he mentions another Court of Appeal authority which is in the bundle, the Newbold and Cole Authority case, and in fact it's convenient just to take that there. If you look at the very bottom of the page, so it's paragraph 60 of the Newbold judgment quoted by Lord Justice Lewison. So Stanley Burnton gives an example of a notice written by his personal assistant, but nonetheless given on his, i.e. Sir Stanley's behalf. The court has read that. We can move over the page to paragraph 28. We don't need to go there. It's more the same as further endorsement of the Queen and Kent Justices. So the simple point is that the principles laid down in the Kent Justices case continue to be applied to this date, including by this court. Consistent with the above, it's clear that an agent can sign documents on behalf of a principal. We've seen examples where that is true. And in common law, a person sufficiently signs a document if it's signed in his name and with his authority by somebody else, whether stating per procurationem or not. Next subpoint is the ability of an agent to declare a trust. And I say this is simply an aspect of the general law. Crescent's focus in its skeleton is on the question of authorization rather than principal. And perhaps the easiest way is if we can go to Crescent Skeleton. So this is Core Bundle, tab 9, page 117. So away from the authority bundle for a moment. Core Bundle, tab 9, page 117. So if we can turn.
So do you have the opus reference for it?
Yes, Core Bundle, tab 9, page 117. So CB / 9117.
Thank you.
Yes. This is Crescent's initial skeleton, and its points made in 2 footnotes at the bottom of the page. Footnote 64, make the point, even at common law, a general power of attorney does not authorise the agent to declare a trust over their principal's property. Paragraph 65 responds to something which NIOC say in their skeleton. If you read down to the bottom, the last 4 lines, in any event, agents cannot usually declare trusts over the assets of their principals without clear express prior authorisation, which would be very unusual. As I said, Crescent's focus on the question of authorisation rather than the question of principle. As I already mentioned, but is worth repeating, there's an acceptance that the mortgage documents, the 2 documents and the August transfer, were found to be declarations of trust. The references in the judgment 187, 188 and 191. Common ground that the judge found that there were declarations of trust. I say that's an end to the point as to whether an agent can declare a trust, at least for this appeal. But in any event, it's difficult to see what is the doctrinal objection. If an agent can enter into a deed or a contract, why should it not be able to declare a trust?
Has the point ever arisen in a case where, and the point decided in the case where it's arisen?
Much less than one might expect. And it's been assumed. I'm going to take you to some of the cases and you'll see the extent of the assistance we get from them. The best starting point.
Would you expect there to be authorities dealing with the question of a declaration of trust by a company, by a trust company, for example, where inevitably the company only signs by a director or officer who, at least on one view of the law, is an agent.
Yeah, well, I can see the logic of that, my lord, but so there is a remarkable lack of authority.
I mean, it's one of the points that stands in your favour.
Yeah. And there are 2 aspects. There's one is obviously ground 1, and the second is ground 2.
Couldn't have declared a trust
Yes.
without somebody acting on its behalf. And so one ends up with a distinction drawn by the respondents between directors and officers on the one hand and other agents on the other.
Yes. We say that's an unprincipled distinction. The best starting point, my lords and lady, is the case of Tierney and Woods. We're back to the authority bundle, AB /122, tab 122. 2476. It's a PDF number, I understand. Now, this is a case it's a short case, it's quite a lot in it, it's worth going into a bit of detail, because this case is sometimes and erroneously cited for the proposition that an agent cannot sign for the purposes of section 53(1)(b).
Yeah.
This was a case on section 7 of the statute of frauds. The crucial point about this case was that it concerned land already held on trust. Tierney held land on trust for Wood. Wood, who then had the beneficial title, made what was effectively a declaration. It's sometimes described as a subtrust. That's not entirely accurate. Made a declaration that Tierney hold the property on behalf of members of his, i.e. Wood's family. The question taken was whether the trustee or the beneficiary was the person who is, by law, enabled to declare a new trust, that being the relevant wording of section 7 of the statute of frauds. And the argument taken by Wood Jr., who sought to claim an interest as the heir to his late father, was that it was the trustee holding the legal title who is the person by law able to declare a new trust. That was rejected by the Master of the Rolls, Sir John Romilly. The crucial passage is at internal page 336. It's page 3 of the opus, within the tab, page 3. And it's the bottom bit. We've sidelined quite a lot of it, starting with the judgment of John Romilly, which gives the background, which I've tried to summarise. If you read from the last paragraph, just under the internal page number 336, reference to authorities show that the proper person to create the trust in personal property is the
Paragraph
person.
beginning, I am at a loss to find.
I beg your pardon?
Paragraph beginning, I am at a loss to
Yes, indeed, my lord.
find. Should we read that?
Please do read it, yes. And if we can move on to page 4, please. Yes, to finish off the last line and a bit of that paragraph. The conclusion there, it's the beneficial owner who's the person by law enabled to declare the trust. If we can move back to page 3, thank you. So the issue there was whether it was the legal owner or the beneficial owner who's able to declare the trust. Master of the Rolls says it's the beneficial owner. And I say that is the key proposition which Tierney establishes, and that is the proposition which lots of subsequent cases and cited for. So I'm going to explain later, it's wrongly sometimes cited for the proposition that an agent can't sign. That wasn't an issue, but the wording at the bottom of page 3 contemplates the ability of Tierney as authorised agent declaring a trust. True it is.
Which words are you relying on? Which words are you relying on for that?
It's the word that says, a declaration of trust in writing by Tierney, following that of Wood, would therefore have been merely formal and would have been valid only so far as it followed his instructions, and would have been void to the extent, if any, that it departed from his directions. And I say that is reality. That's the word of agent, language of agency.
It's slightly odd, isn't it? Because it's following that of Wood, so following a declaration of trust
Yes.
by Wood. So
Yes.
it'd be an irrelevant
Well,
document.
yeah, it either adds nothing,
Yes.
if it's, but nonetheless, he's contemplating the prospect. And we'll see that Lewin describes the legal owner as being a conduit. That perhaps is where some of the confusion subsequently arose. But the key point here is that the main proposition is it's the beneficial owner of the trust. That's not challenged, that is established law. If it does say anything on agency, I say it contemplates the prospect that an agent, albeit in this slightly unusual situation, can declare a trust if authorised. And I say that if that is the position where there is a declaration of trust, there's absolutely no reason why it shouldn't be the case where there isn't a declaration of trust to start with. The ordinary position as in here, where the absolute owner then declares a trust, or an agent on behalf of the absolute owner thereby declares a trust.
The one point in this case is it's interpreting the words "is able to,"
Yes.
which appear then in section 53(1)(b). Arguably, we should be interpreting those words in 53(1)(b) with reference to
Well,
this. Arguably, what this case.
there's a number of
tells
points
us.
in that, my lady. First of all, again, there is the wording that it's by law enabled or able to, which hasn't survived into section 53(1)(b).
No, but it does say
But
"is
yes.
able to," which is a slightly odd choice of words.
Yes. Yes, and now it's slightly different.
And this case
Yes.
maybe gives us an indication as to those words were intended to mean.
Is able to, I say, clearly goes beyond the person who actually did.
Potentially,
Yeah.
yes,
Yeah.
but potentially also it's telling us that one of the things that it's getting at, or maybe the main thing, is are you the right person to declare this trust? In Tierney and Wood, the answer was that the existing trustee was not.
Yeah.
And similarly, if you apply that in a 53(1)(b) context, you would presumably say that the same applied.
Well, again, it's like,
If you had these facts.
yes, if you had those facts. If you don't have those facts, you don't have the complication of the argument between legal owner and beneficial owner, which is that that was the essence of the argument in that case. That's why Wood Jr. relied upon that to say that the appropriate person to declare the trust was Tierney, not Wood.
But what I'm
Yeah.
ultimately driving at
Yeah.
is this, which is I'm not sure if you are. To what extent does your argument rely on interpreting the words "is able to" as meaning authorised? So when you get to 53(1)(b),
Yeah.
one possible interpretation of the words "is able to" means I'm a person authorised to do it. Tierney is putting a rather different interpretation on this.
The wording in under section 7 was who is by law enabled to declare such trust. Now we've got the wording who is able.
Yeah.
So that's the first point. But in terms of, if we're looking just at section 53(1)(b) for the moment, we say, and I'm jumping ahead, I'm going to get onto the plain wording in due course, but I'm happy to deal with it now.
Well, the
Yes.
reason I'm raising
Yes.
it now is that this case
Yeah.
is part of what prompted the
Yeah.
thought process that led to
Yeah.
the question.
The funded position which I'm endeavouring to develop is that at common law, an agent can, amongst other things, declare a trust. That's the common law position. Then when looking at the construction of section 53(1)(b) against that context, some person, not the person, but some person who is able to declare such trust for his will, we say includes an agent properly authorised.
Yes.
Back to the authority on the ability of an agent to declare a trust. The position was assumed in the case of High Commissioner for Pakistan. It's a an unusual and complicated case factually. I can simply tell you what the position is, that in there, Mr. Justice Marcus Smith proceeded on the basis that a properly authorised agent could declare a trust, but there was no argument, and in fact he found there was no authorisation in that case. So one can take that on those terms. So that is the what I wish to say about the ability of an agent to declare a trust at common law. Surprising lack of treatment of it, perhaps because it is so obvious, but for whatever reason, I say it's simply an aspect of the general ability of an agent to do everything on behalf of the principal that the principal could do. Now moving on to the plain wording of section 53(1)(b), we've foreshadowed some of this. I say that with the benefit of a proper understanding of the common law, the plain wording becomes ever more plain. And while I acknowledge it's clearly possible for a statute to require that a signature is given by a specific person and not by his agent, one finds no such requirement in the plain wording of section 53(1)(b). Perhaps we can turn to that. It's Authorities Bundle, tab 8, AB 8. (80) in the PDF, my lord. You may already be there. Declaration of trust respecting any land or any interest therein must be manifested and proved by some writing signed by some person who is able to declare such trust or by his will. And the fund says that the judge, with great respect, did not look at the plain wording and moved straight to a comparison with subparagraphs A and C. We just said the language is some person, which I say clearly includes a body corporate who is able to declare trusts. Moreover, some person clearly means or allows the possibility of more than one person. Thus allows the possibility that more than one person can declare a trust. The only sensible conclusion is that this includes someone acting on behalf of the settlor, i.e. their agent. The reference to those able to declare trusts is a reference to the common law. As already explained, that includes an agent. Had the intention been to lay down rules as to who is and is not entitled to declare a trust, and limit to who can sign the proof to say the settlor, then the section could well have said so. The judge's contrast with section 53(1)(a) and (c) failed to recognise the different functions of the various provisions. As is common ground between the parties, A and C are substantive provisions, while section 53(1)(b) is an evidential provision. Present in their skeleton. Sorry.
Leaving aside
Yes.
the question of agency for the moment, B is very different to A and C, because A and C identify that the writing must be by the person making the disposition, creating the conveyance, etc. B contains no reference at all to the person who has the interest. It doesn't require the person having the interest to make the declaration. But in what circumstances could anyone but, as I say, leaving aside agency, in what circumstances could anybody but the person who holds the relevant interest in land declare a trust over it?
Well, it's a question I've asked myself, and it's difficult to come up with the answer. It clearly needs to be the beneficial owner. I suppose it could be their heirs or assignees or someone else who applies by law. I'm just sort of thinking through what else it could be, but clearly it all ties back to who has the beneficial interest and is thus able to declare that. And we say, you know, whatever the other parameters may be, clearly that includes an agent.
Doesn't that really slightly beg the question? That's what I was getting at earlier.
Yes.
Able to declare. Tierney tells us
Yes.
you've got to be the beneficial owner.
Yes.
That gives meaning to those words. That doesn't necessarily include an agent.
Sorry, can you repeat that?
Doesn't necessarily include an agent. And I'm sure you'll come on to this, but you've also got to deal with the words "or by his will."
Yes, I'm going to come on to it, or by his will. I'll do that in due course. Now, the next point I was going to make, and we've touched on a bit of it already, is that A and C are substantive provisions, while B is an evidential provision. So B is concerned with the written proof of the declaration. A and C concern the actual substantive actions. We know that the writing, the signing, need not be contemporaneous with the declaration of trust. The trust takes effect from the date of the
That's the point,
declaration.
isn't it? That B is predicated on the possibility that the manifestation or proving by writing is not contemporaneous with the declaration. It may be, there may be only one document, which is a declaration of trust, but Gardner and Rowe suggests that that's not the position.
That's the best example of the
And
position.
so you can have an oral declaration of trust, and then subsequent writing signed by some person who's able to declare. But that, as my lady said, tends to bring one back to the person who's actually declared the trust, which will be the legal owner, the settlor. Leaving aside the agency point, I mean, as my lord says, you know, the agency point is if you're right about it, then none of this matters.
Can I also ask, when you say, which is clearly right, that B is evidential and whereas A and C deal with the operative transfer or creation, yes, it's a way to distinguish the paragraphs, but how much further than that does the point go? Why does it point to your argument being right rather than...
Because that's only part of the difference of them. And I'm about to come on to the very point. The reason why agents are mentioned in A and C is to specify they must be lawfully authorised in writing, i.e. an oral authorisation is not enough. that's more onerous than the common law position from which it departs. Without such limiting words as one sees in A&C, the common law position applies. And this is the very point my lady is hinting at. It's important to appreciate that the specification in A&C that agents must be expressly authorised in writing is a limiting provision, as opposed to an empowering one. Contrary to what the judge said at paragraph 197 of his judgment, it's not a question of whether the writing is sufficient. It's whether writing is necessary, having regard to the common law. Unlike A and C, there's no stipulation in B that an agent must be authorised in writing. Accordingly, absent clear words to the contrary, which we say is not the case, there is nothing in section 53(1)(b) which departs from the common law rules of agency, both as to the underlying declaration of trust and the ability to sign the evidential writing. Accordingly, an agent can sign and it need not be authorised in writing. If people focus in on A and C and say, look, there's express mention of agency, and that's exactly what the judge did. But it's important to understand that by saying, A, for example, no interest in land can be created or disposed of except by writing, that's imposing a requirement of writing, or by his agent, therefore lawfully authorised in writing, a second requirement of written authorisation. So there are two conditions you have to overcome there. In B, say the only condition is that the proof has to be in signed writing. Doesn't specify how the authorisation comes about. You know, an oral declaration will suffice as long as there is subsequent, potentially previous writing. Now, the point's been made by NIOC and its skeleton that it's sensible in the context of A and C to specify the need for written authorisation when you're talking about substantive provisions which have to be in writing. Crescent say that the fact that section 53(1)(b) is concerned only with proof is all the more reason why an agent should not be able to sign. I say with great respect that is counterintuitive. It amounts to saying that where the legislation does not require a substantive act, for example the declaration, to be in writing, this supports having a narrow class of people who can sign the proof. We now come on to the or by his will point. This was a point not taken by Crescent below, but they raise it now, and they say that the final words, or by his will, cannot refer to an agent, and thus must mean that some person, in the context of B, cannot include an agent. Now, the fund's position is that that argument reverses the correct order of things and is a case of the tail wagging the dog. They say just because an agent is unlikely to be able to dispose of his property or the property by his will, he cannot be within the meaning of some person who is able to declare a trust. We say that's an unusual reading, which doesn't constitute sufficiently clear wording to depart from the common law position. Take a simple example. A company can obviously declare a trust, going back to my lord's example earlier, over land, but cannot dispose of its land by will. On Crescent's approach to construction, placing undue emphasis on the word by his will would lead to the consequence that a company would not be able to evidence a trust over its land at all. That cannot, and thankfully is not, the law. Another example is the Garden and Row example. My lord clearly has the facts of that in mind. The crucial bit is by the time of the written proof, the individual was bankrupt. Wasn't able to declare a trust, but was able to sign the effective section 53(1)(b) document.
Yeah.
It follows that the person who is able to sign a memorandum for the purpose of section 53(1)(b) is not necessarily the same person or in the same categorisation as the person who can declare the trust in the first place. We say that the natural way.
The statute of frauds was enacted.
I beg your pardon?
At the time when the statute
Yes.
of frauds was enacted, it's pre any of the Companies Acts.
Pre-Companies Act, although corporations of some sort do exist.
And so
Yes.
when it talks about or by his last will in writing, it clearly did mean an individual.
Yeah.
But
It
you
clearly-
say, well, that may be right as a matter of history.
By
Once you get into a
1925.
modern context or more modern context where clearly a company can declare a trust. You can't use the words "all by his will" to as it were, reverse engineer into a position where the company can't declare a trust because it can't have a will.
Exactly, I couldn't have put it better. All it does is identify a specific form of document by which a declaration might be satisfied. You can't infer from that that other means of doing it are excluded.
Yeah.
And it leads to a concluding point in this section of my submissions, that if an agent can create or dispose of an interest in land, look at subsections A and C, why should it not be able to declare a trust? Of course, I recognise, I've said this before, that plain wording could exclude that, but there's no such wording here. Well, it's 11:40. I'm conscious the shorthand writer's been going for an hour and 10 minutes. Would that be a convenient point
Well,
to
if
take a
you've
break?
reached a point where you're moving on to something else.
I'm about to move on to the history of section 53(1).
Yeah, okay, let's have a break.
If we could stick to 5 minutes, so just after 11:45 by that clock, which is slightly faster, I think, usually is.
We are making reasonable progress.
Good. Excellent.
All rise. It's okay now, don't you? There's something technical issues as well.
Hi there. The lady from Opus just told me that someone's coming, I think. Yeah.
Next time we might have a word about the
Configuring. Yes, definitely.
focusing on to running all that.
Yeah.
More observation.
No, certainly. Yeah, I mean, I'd plotted various options out, but prior to their determination of what order they want to hear.
Well, why don't when you guys are open,
Yes.
dual grounds 1 to 3,
Yes.
plus the overlapping brackets,
So that brings in the North Point which is banking I should be talking to.
Yeah.
Shall we do it?
Yeah, well, it probably makes more sense because
Yeah, okay. All right. I just think that we'll find it unsatisfactory if we haven't got a timetable by after lunch.
Yeah.
We can't sort it out in 5 minutes.
Yeah, exactly.
It's going to take longer than 5 minutes to do it, I'm afraid. They've resent, he just needs to be able to log in. So they've resent him a link to, because he can remember his password. So as soon as he logs in, it will take him 30 seconds to do. Yes, yeah, definitely.
Thank you. Shall we have a word about the timetable on lunch? Because I think Bill wants some.
Sure.
Yeah.
We have discussed between ourselves what we should do. We think that you should address us, between you, you should address us on everything, because it seems to us at least the first point in the respondent's notice is really goes naturally with grounds 1 and with to thank his grounds 1 to 3. And otherwise it all sort of divides up too much, I think. So unless that's going to really cause Mr. Equator problems, and I can't at the moment see why it should, he'll get his say. And I'm sure he'll use it to the full.
That's not a question I propose to answer on Mr. McQuater's behalf. But, suffice to say that at Mr. McQuater's suggestion, we will discuss over lunchtime the timetable and report back at 2 o'clock on
Okay,
that front.
good, that's fine.
The history of section 53(1)(b, we've touched on aspects of this. The easiest way to make my points as quickly as I can is by reference to the hard copy table I handed up this morning.
Yes.
I already described briefly and won't repeat. One can see from it which sections of the 1677 Act appear in a slightly different form in 1925. The first point to make is that what's now A, B and C appeared differently in different parts of the previous legislation. They've now been grouped together. I make the perhaps trite point that legislative drafting techniques back in 1677 were rather different to practices adopted today by parliamentary council. We'll come on to aspects of this in due course. Crescent have said in their supplementary skeleton, we don't need to go to it, that it's not appropriate to draw comparisons between some provisions of statutory frauds and the successor provisions. my simple point is this, that Gray in the IRC, or indeed any other authority, does not bar the court from making such comparisons. The speeches there simply show that the utility to be derived with the exercise will vary from case to case. Where subsequent legislation is similar to predecessor legislation, the past is relevant. Where it's substantially different, there's presumed to be a change, and the focus of the old legislation is the fact and the extent of that change. There are three aspects of the language of note. Again, let's do this from the table. In section 7, the statute of frauds. The first is 4 lines down to the high line, but manifested and proved by some writing. That survives in section 53(1)(b). The next bit is on the same line in section 7, signed by the party who is by law enabled to declare such trust. Similar language, but with some differences, appears now. Signed by some person who is able to declare such trusts. And I've already highlighted the stress I place on the word some person. Not the person, but some person. And the third point is the last line of section 7, utterly void and of none effect. That has been deleted, no longer exists. Submissions on that point relate to ground 3, and respondents notice 1. I'll say nothing in relation to that. Another point Crescent make in their skeleton is that manifest and prove cannot be tautologous and connote two different concepts, with manifest connoting the coming into existence of a trust. That argument does not bear scrutiny for 4 reasons. First of all, it's contrary to the acceptance elsewhere on behalf of Crescent that section 53(1)(b) is concerned with written proof. Secondly, it ignores the fact that drafting approaches have changed since 1677. You will be aware it was commonplace to use lexical doublets such as will and testament, aid and abet, goods and chattels. The phrase manifest and prove is simply a portmanteau provision. Furthermore, as a matter of dictionary meaning, manifest means to reveal. And towards the end of what was the authorities bundle, tabs 171 and 172 are extracts from dictionaries, but the points made in NIOC skeletons. Manifest means to reveal. Fourth and final point is, even if contrary to the above, manifest did mean declare or create, such that the substantive declaration had to be in writing. The requirement of written proof would be surplusage itself. That's all I wish to say on the legislative history. We now turn to the authorities. So my Lord the Chancellor has already identified there is no binding authority. I would put it even further, there is no case in which the point currently before this court has been argued, let alone determined, following argument. My second point is that such cases as do exist and do mention the ability of agents to sign for the purposes of the section, or predecessor or comparable provisions, are few and far between, and either based on a misreading or misunderstanding of Tierney and or are obiter, unargued and brief. The third point is when we get on to other statutes, each of them have to be looked at to their own terms. I've already explained the starting presumption of the qui facit rule. One has to look at each statute to see whether there is a clear departure from that. I've already covered Tierney and Wood and said it's whatever it is, it's not authority for the proposition that an agent cannot sign. The only other case really on section 7 was Cronheim and Johnson. We don't need to go to it, but I'll explain briefly what it is. It's another trust case. It simply followed Tierney for the fact that it's the beneficial owner who can declare. In that case, it was academic because the document in question was not signed. So it adds nothing to Tierney. One sees in some of the commentary added on. Belts and braces. Turning to section 53(1)(b), there are 4 cases relied upon by Crescent. I say none of them was the point argued. In some cases, the point wasn't even before the court. The first case is the case of Her Royal Highness Tessé, Princess of Luxembourg. That's AB 63 24, page 24. 1278, my lord.
Yes.
No, actually, I'm so sorry. Can we move back to page 11 first of all? Within this? So this is a case that really turned on the Nemo DAT rule and whether an indication in a TR1 land registry transfer form that the husband and his father held property as joint tenants could be relied upon by the wife. So paragraph 25 of the judgment sidelined. If you just read to yourselves to understand the nub of the wife's argument. And then we move on to the bottom of the page, this page, paragraph 28, the husband's denial that he's the beneficial owner. And then if we just 2 seconds to absorb the bottom, and then move over the page, top, husband's explanation. So it's really the first few lines that he and his father held the property as nominees bear trustees.
For the ADB, what's the ADB?
That's, I think, it's sort of a corporate trust. We can now move on page 24 to paragraph 67. You'll see there, statement, only person able to declare a trust may do so. When the property is held in trust, it's only the beneficial owner who's able to declare the trusted land for the purpose of section 53(1) of the Act. So far, all compliant with Tierney. Then Mr. Leach QC, as he then was, cites from the then...
Mr. Leach.
Sorry?
Different.
No, you're quite right. It's
not
the other
Mr.
Leach,
Tom
yes.
Leach, it's
Yes.
Mr. I think
Yeah.
Francis
Stuart
Leach. is a
Leach,
family
I do
sort of
apologise. Paragraph 68, the judgment citing from the then 19th edition of Lewin on Trusts.
It's the same text as now,
Yes, it is, exactly.
but that last sentence,
Yes.
which obviously is relied on, doesn't. In Lewin, there's no authority cited for that proposition.
No, and we'll see that historically in the 13th edition of Lewin, that last proposition about the agent was separate from the bit about Tierney and the beneficial owner, and then they've been grafted to subsequent paragraphs in time. We just have the point there. So, no arguments to agency in this case whatsoever. Lewin's just cited there, and the agency point only appears because it appears in the bit of Lewin which is relied upon. So I say that doesn't advance the matter at all. The next case is the case of St Ermines, AB 114 2337. Now, this concerned the validity or otherwise of a notice under section 42 of the Leasehold Reform Housing and Urban Development Act 1993. One needed to see whether documents complied with section 42 and section 99 of the Act. You can see the summary of the decision in the case report H2 on the page on the screen. That held that there had to be personal signing by the tenant, couldn't be signature on the tenant's behalf. We move on to page, it's paragraph 18, which I think is page 6. Yes. That sets out sideline bit, paragraph 18, section 99 of the Leasehold Reform Act. And you'll see there's provisions there. A, by the tenant by whom it is given, and B, by or on behalf of each of the tenants. And that's really the essence of the argument which succeeded, that there was express difference between the wording of A and B, and that the use of by or on behalf of the tenant in B helped one understand what by the tenant in A meant. We can move over the page to paragraph 26, please. And there is then reference to section 53(1)(b) of the Law of the Property Act. So not before the court in that case, simply by comparison. And 3 lines from the bottom, reference to the impermissibility of signature by an agent. So not a provision before the court, not and thus obiter, not apparently the product of any reasoned argument on that. I say,
Hayden Johnson
yes,
was a case decided under Lord Tenterden's Act,
Yes.
is that right? You get that
It
from
is.
paragraph 23, and the point
Yes.
is, that was, we've got that, have we?
no, we don't have that. So we do,
That's
sorry.
what it says.
No, we have,
Oh, we don't have the act.
No. Yeah, so Hayden Johnson was on section 1 of Lord Tenterden's Act. That was the ability of a debtor to revive a time-barred debt, and held that it had to be personal. And that was again consequence of the proper reading of that act. We see the end of 26. As it happens, consequence of Hayden Johnson, Lord Tenterden's Act was amended in 1856 to allow signature by an agent. I'll come back to that point in due course. My point was that all the reference in Ermans about section 53(1)(b) is obiter, not the product apparently of any reasoned argument.
no.
Finally, there are 2 cases on section 53(1)(b) decided by His Honour Judge Halliwell, where the agency point again was not argued. The first one is Morton and Morton. That's AB 82. The conclusion, that's 1670, my lord.
Yeah.
The question in that case was whether documents signed by a partnership's accountant satisfy section 53(1)(b). If I can ask Opus to turn to page 29 within the bundle. That's paragraph 100. So page 29. 1699. If I can ask the court to read that yourselves, please. I should say Mr. Edwards was for the defendants, Simon and Alison, as the counsel referred to 5 lines down, 4 lines down.
Yeah.
Again, not the product of any argument, simply a statement in there. Fourth and final case on section 53(1)(b).
When you say not the product of any argument, why do you say that?
Well, as to whether agents, whether a signature by an agent could declare a trust.
I mean, I've read, I must say the same as the other case of Judge Halliwell's, that he was reflecting what had been argued before him. Because presumably what was being argued before him was that signature by the partnership accountants wasn't good enough for the purposes of 53(1)(b).
Okay, well, one doesn't see the argument.
Otherwise it just sort of springs out of nowhere. I mean,
Well,
why on earth is he referring to it
Yeah.
if that wasn't what was being argued?
In this case, it says Mr. Edwards did not submit that any of the partnership accounts could satisfy
Yeah.
the formalities.
That's the point. So it was those accounts signed by the partnership accounts, as to whether those, I as agent for the individuals, whether those could satisfy the wording. So that argument wasn't run by Mr. Edwards. And then he just concludes, as His Honour Judge Hale concludes, that had there have been no argument to the contrary, that they couldn't suffice because they were signed by an agent. Fourth case is Fish and Sky Apartments, AB 44. 784. Again, His Honour Judge Halliwell. And here, the point about section 53(1)(b) is cited in an opinion given by counsel, which is referred to in the judgment. If we start if we turn over the page 2, you can see, if you just read briefly, particularly paragraph 3, to understand the issue in that case, whether certain investors were beneficiaries under a constructive trust.
Yeah.
And you'll see the last 3 lines in 3, an opinion from Mr. Richard Moore of Council. That's the opinion which we'll come to in due course. Then paragraph 46, which is page 13, I think. Yes, we'll need to move the page, the constructive trust issue. Mr. Fennell was for the investors unprotected by registration. He was arguing for a constructive trust in a broad form applying. Will you turn over the page, page 14, please? And there's then, you can see even by the names of the cases at the top of that page, the nature of the argument taking place. We then move on over the page, page 51. 51, Mr. Fennell continuing, and then we'll move on to section 5, notice. And then 5 lines down, the judge says, in my judgment, the section 5 notices do not assist him for the following reasons. First, not contained in the operative disposition of the registered title, they were made upwards of 2 years afterwards. Secondly, as Mr. Moore observed in his opinion, notice does not contain a comprehensive and narrowly defined description of the rights to which the proposed disposal was intended to be made subject. Simply recording the disposal was intended to be subject to the leases, tenancy agreements, occupancies and other interests affecting the property that existed at the date of the proposed disposal. And then we, last line, then read over the page. The factual background is obscure. Mr. Moore also observed that if otherwise apt to do so, which on the face of it they weren't, the section 5 notices would not have been capable of constituting a declaration of trust pursuant to section 53(1)(b) because they were signed by an agent. Even if one is to assume that Sir Judge Hallowell is implicitly endorsing that, it's not express, it's an obiter comment if that, within the context of the opinion, and the point wasn't argued before the judge. Those are the 4 cases on section 53(1)(b), and I say not a lot can be drawn from them. Crescent have recently located a decision in the New South Wales District Registry in a case called Di Pietro, AB 39 657 650, sorry. Now this considers similar New South Wales wording to section 53(1)(b). Cutting to the chase, it's based on a misreading of Teare. Can we turn, please, to page 7 within the tab? Internal 476. The court can see B to D, the provisions of the Conveyancing Act, clearly based on 1925 Act.
Yeah, it's ironic, isn't it? Because it was a Conveyancing Act of 1919 of New South Wales.
Sorry, yeah.
Whereas my dim and distant recollection of the genesis of the Law of Property Act is that there were various amendments, there were various acts that were passed after the First World War. But the first of them wasn't in this jurisdiction, wasn't until about 1922, I don't think.
Yeah, and there was Acts in 24, and then you have this big sweep of the consolidation.
The 25 Act is actually consolidating
It's 24.
statute.
Yes.
So the Australians must have been ahead of us, which is interesting. Yeah.
So that's the section. Then the crucial paragraph is page 12. So we can turn that. Thank you. Yes, it's the sideline bit D to F of the report. And you'll see the reliance placed on Tierney, and I can just ask the court to read that to yourselves, please. you can see the conclusion is grounded in Tierney. As I've said before, Tierney is not authority for that proposition that an agent cannot sign. And in any event, the decision is clearly only persuasive, and I would say, with great respect, at a lower level from most Australian cases which are shown before this court. Now wish to move on to provisions in other statutes. Now, there are lots of examples given, so I shall try and take this as quickly as I can. I've said before, but it bears repeating. Each statute must ultimately be considered on its own terms.
Yeah.
Some will point one way, some will point the others, depending on the wording. That being so, I confine myself to 2 points. First, there are several cases on Section 99 of the Leasehold Reform Act concerning a tenant's notice seeking an extended lease. We've seen St Ermines. There are at least 2 other cases. I'll give you the names, I won't take you to them. One's called Cascades, AB 31, Court of Appeal, and the other one is Hilmy, which we might hear in the context of Ground 2. All of those are consistent that the plain wording of Section 99 required a personal signature. As I said before, the critical bit is the difference between the wording by in one subsection and by or on behalf of in the other. That wording has since been amended, and one can see that if we go to Authorities Bundle 17, AB 17, I think there's 1770, yes, it's for the courts when it says 17, 17.1 and 17.2, which are 3 iterations of the Act. What we currently have is the current version, 99 to...
Yeah, so that's clear from the italicised bit at the top, isn't it? Up to date to the 16th of June 2025.
So we can move over the page, please. 99.5. You see the current wordings, be signed by or on behalf of each of the tenants. So that has been amended from what was there before to get around the conclusions in St Ermines, Cascades, Hilmy. Crescent rely upon the words of that statute and the fact that a statute was required to the conclusion of those cases. But I say in reality it's testament to the importance of the words and the fact that in that case the words were plain but the other way. And the fact of the statutory amendment is testament to the impracticality of the conclusion or the findings of those cases I've just mentioned. Otherwise there'd be no need for the amendment. Legislative amendment was required there because of the plain wording. It's not required in our case, but it highlights the impracticality of holding that a personal signature is required in some circumstances. Second and final point on the other cases is that some of the cases Crescent relies upon are of a completely different context. And again, in the interest of time, I won't take you to them unless you wish me to. First one was Banbury and Bank of Montreal, which was a case about liability and deceit. House of Lords there held that signed writing under Section 6 of the Statutory Frauds Amendment Act could not be made by an agent. Mr. Thankey will develop the question of how companies sign in due course. Second point, Bennion at 25.3 refers to a case called Grease and O'Connor, which is in Crescent Skeleton. It's not in the Authorities Bundle. That was a case concerning Section 26(5) of the Extradition Act 2003, concerns the court's jurisdiction to entertain an application for leave to appeal against an extradition order out of time. The question is whether the person facing extradition did everything reasonably possible to ensure that the notice was given as soon as it could be. The Supreme Court held that the person, term person, did not include an agent, according to the natural meaning. And one can well see why, in the circumstance of that case, courts may well be impelled to that conclusion, but it's a very, very different context, the one we are concerned with. My Lords, now turn to the commentary, some of which we've touched on already. parties have diligently found multiple books and articles in this jurisdiction and elsewhere, I say that broadly speaking they can be broken down into 5 categories. First of all, where there's some proper analysis of the wording, the implications and the rationale. I say that notably all those authorities support the ability of agents being able to sign for the purposes of section 53(1)(b). Second, authorities which note the presumption or the understanding that agents cannot sign and question why that is so. Third, articles and commentary which do little more than note that there is no express provision in section 53(1)(b) for agents in contrast to A and C. In other words, the approach that the judge took. Fourth, commentary which relies upon tyranny, and I say stands or falls by the proper reading of that case. And fifthly, cases which have nothing to do with agents, but Crescent relies upon as, commentary which has nothing to do with agents, but Crescent relies upon as showing the importance of formalities. And I'm not proposing to deal with those at all. So starting with the first category, the proper analysis, there are 3 books or articles on which the fund relies. First by Charles Harpham, second by Professor Paul Davies and Corton Graham Virgo, and the third by Professor Udan. I'll take them in order. Some of them are set out in the skeletons. It might be useful to go to the actual underlying documents. So first of all, the analysis by Charles Harpham, a then Law Commissioner and head of the Property and Trust Law team, and responsible for what became the Land Registration Act. In a chapter from 2000, it's AB 136, page 10. So the chapter's called Property in the Electronic Age. Page 10, internal page 12, we see the red sideline section. It's the second half of it that is of concern. There's a sentence beginning sort of halfway along. Those who say that an agent cannot make such a declaration, if I can ask the court to read that.
Just disappeared off the screen for some
You
reason.
mean 12, which page do you mean?
It's on, well, I guess it's on my screen. I think
No, it's my screen's gone blank.
I do apologise.
What's the which tab is it?
It's tab 136, which is volume 5 of the hard copies. 2839 in the PDF, my lord.
Page,
May already be there.
page 10.
So yeah, Opus page 10, internal page 12. You should see the red sideline section.
Paragraphs 1A and C require something is done in writing, not only should be evidence in writing.
Yeah. Exactly, so it's just a couple of lines above that, to the end of that paragraph. If you're happy, we can move on to Davies and Virgo. This is AB 151. Still, if you're doing a hard copy, still within volume 5. Opus page 5. The sideline section discussing the choice between A and B and the consequences of that. And then the question of agents, again, if I can invite the court to read that those 2 paragraphs there. I respectfully endorse the observation this would be a sensible, practical interpretation. We can now move on to the third authority, which is Professor Udan. So this is AB 133, again volume 5, so tab 133. 2767. We're really interested, and then it's page 11, opus page 11. What we're really focused in is footnote 51, which hopefully is large enough to be read. The text basically summarises what happened in Tierney and say that Tierney states what's surely obvious when land's held under existing trust. A further trust is required to be evidenced in the writing signed not by the trustee but by the beneficial owner. Footnote 51 is where Professor Udan engages with the question of agents. I invite the court to read that footnote. So those are the three authorities in the first category I gave, which give some proper reasoning, justification for the stance. The second category is ones which note the assumption that an agent can't sign, but then question why. There's a few of them. Perhaps the best one to go to is Hayton, McFarlane, and Mitchell. That is AB 157. Page 4, again, volume 5. 3194. Paragraph 6.031. Simply invite the court to read that paragraph yourselves. Then the third category, authorities which say that agents cannot sign simply because there's no express reference. The obvious example is Lewin on Trust, which we've looked to before. Don't need to go to that again. Yeah. Fourth category, commentary which relies on Tierney for the proposition. There's at least one express example and a few more where one has to do a bit more work, but it's, I think, tolerably clear that Tierney is being cited for the proposition. Can we start with AB 132? This is Wolstenholme and Cherry's Conveying Statutes from 1972, edited by Professor Farrand. Volume 5, those in hard copy. Page 5 within that. 2766 PDF. If we look at the right-hand page, I wonder if we can enlarge this.
Yeah. Oh yes, in paragraph B, super the words mean the owner of the beneficial interest in himself, not his agent.
Yeah.
Tierney and Wood and Graham's IRC.
Yes.
So what does Gray have to say on that?
What? I mean, the case Gray as opposed to Gray and
Yes.
Gray. Yes. Well, that was the case on section 53(1)(c). I say it doesn't bear on this.
But it's cited.
Yes. Well, that unfortunately, Tierney cited for something it's not proposition for either. But there you see an unequivocal assertion that Tierney stands for something it doesn't. Next place, if we can go to McGarry and Wade, so that's AB 167. Again, volume 5. Can we start with opus page 3, please? 3330. Now, this requires us to navigate between two separate paragraphs. Start with 10.042, sideline bit, internal C, some person who is able to declare such trust. Again, owner of the beneficial interest. Signature of the trustee is not sufficient. Footnote 317, Tierney and Cronheim, which I mentioned in passing. Nothing about agents there. Can we then move on, I think it's 2 pages to 10049. Yes. And it's contrasting, this is now talking about section 53(1)(c), contrasting it with B, the rule for the creation of a trust of land with the signature of an agent is not enough. Footnote 343, see above para 10042, what we just looked at. So the only basis for that can be Tierney as an improper use of that authority.
Yeah.
For what it's worth, Jacob's Law of Trusts, Australian book, cites Tierney, Ryder and Di Pietro together. Apparently, it's not entirely clear for the same proposition. I won't trouble the court to go to that. So that's the fourth category of authority, relying upon Tierney, I say wrongly, for the proposition. Fifth one is the commentary purely on the importance of formalities, which as I said I wasn't going to take you to, and I shan't. We now move on to the consequences if the judge's construction is correct. My starting point is that courts can and should have regard to the consequences of one construction over another. I've referred to the relevant principle of interpretation already. Crescent's argument that enabling an agent to sign facilitates fraud ignores the reason or the rationale for the statute of frauds back in 1677, which was to stop perjury, perjured evidence, and also ignores the reality that agency is an integral part of commercial life. It can be profoundly impractical if legal persons cannot use agents to conduct business on their behalf. As a counterweight to concerns about fraud, which I say are overplayed, there's always the risk that formalities frustrate a party's intention and prejudice others. I've made the point it's significant that Section 99, the Leasehold Reform Act, was amended expressly to enable agents to sign, as was Section 1 of Lord Tenterton's Act. Those were cases where there was a clear perceived impracticality of the outcome of those cases. An amendment to the legislation was required. In terms of the impracticality and consequences which the judge's construction leads to, I'll give 3 examples. The first of all, imagine the following situation. Mrs. P makes an oral declaration of trust of land for members of her family. Later, those members, the beneficiaries, write to her requesting written confirmation. She responds to that request by asking her solicitors to write on her behalf. The solicitors duly write saying, happy to confirm that on date X, Mrs. P declared herself trustee of the house for you. On the judge's construction, that letter would be inadmissible to prove the trust, written by an agent. This is a variant of the facts in Ong and Ping, which we'll come to in due course. The fact that the writing, as a point I made before, need not be contemporaneous with the declaration increases the desirability that someone other than the beneficial owner, i.e. the agent, can sign for the purposes of 53(1)(b). Second observation is this: the consequences of the judge's construction are severe for those who have capacity issues, who are dependent upon agents to act with the outside world, whether a lasting power of attorney or whatever. The judgment would prevent such people from being able to declare a trust on their behalf. The third point, there are potential implications in a domestic conveyancing situation and specifically for land registry TR1 forms. We saw some aspect of this in the Tessie case. The TR1 in this case is in Supplemental Bundle 47, SB 47, page 386. Anyone using the hard copy, it's the volume 2 of the hard copy.
What was the page number again?
SB
Sorry.
47, 386.
386.
This is the TR1 in this case. You can see box 10. This is declaration of trust. Transferee is more than one person, and that is where one specifies if there is more than one transferee, they specify on what trusts they hold. Now, relevant in this case, for obvious reasons, but in other cases, frequently in a family context, property might be bought by father and daughter, wife, whatever. We see father and son in Tessie, and one would expect the form to be filled in that instance. The point is this: if the judge is correct and agents cannot sign on behalf of those with beneficial interest, there is the possibility that some TR1 forms will not be effective because they've been completed by the agent, normally the transferee's solicitor.
Normal conveyancing practice is the transferor actually executes,
Yes.
even though the form's filled in by the solicitor. So I'm not sure.
The
it's
transferor, we'll come on to, in fact, let's just move on to answer my lady's question. Can we move on? Next page, please.
Are you saying they aren't normally associated by the transferee?
Yeah. So here's an example where only the transferor has executed.
Right. So your
But-
point is about the transferee.
The transferee, in a case where there is a declaration of trust, and one can see this from the guidance notes on the left of there, the transferees would have to sign there. That's what's supposed to be done. If that is done by the transferees, all well and good. But there have been cases where that hasn't been done. Sometimes there have been box ticks, but it's just the transferor who appears there. Sometimes the whole form may be completed by a solicitor acting on behalf of someone.
But if it's not signed by the transferee wrongly, it's not going to be signed by the solicitor, is it?
It's not in,
The form might be filled in by the solicitor, but not signed.
well, that might lead to the nice question of whether the ticks in box 10 by a solicitor and box 12, the signature by the transferee, constitute a declaration of trust by them.
Sorry, I
Yes.
thought you were making the point, which may not be a major point, I thought you were making the point that sometimes it is not executed on behalf of the transferee when it should be, or by the transferee when it should
That,
be. In that case, it won't be executed by the solicitors either.
if it's not filled in at all, not a problem we're concerned with. The problem is if it is filled in by someone other than the transferee. And it might be by a transferee's solicitor. Conveyancing normally been done through solicitors. There's at least one case where it's done by the transferor. Point being, if the judge's construction is correct, the apparent declaration of trust within TR1 would not be manifest and proved by signed writing because an agent, whether it's the solicitor or someone else, could not sign on their behalf. I'm sorry, I'm clearly not making myself
No,
clear.
I just can't see how you're helped by this, because if it's not signed by the transferee, it won't be signed by their solicitor either. And your case is about signing by an agent, not filling in a form.
No, but the point I'm labouring to make here is that if it is signed by someone else, in the belief that that is permissible, the judge's construction would lead to the fact that there would be no declaration
Does it come
of
to
trust.
this, if box 10 had been filled in,
Yes,
then the transferee, as in the fund, would have had to execute this as well.
assuming it was more than one transfer.
Then the issue is,
Yeah.
it would have been doing that through an agent.
Yes,
that's
and
what
that
happens, is it?
exactly, and so that I mean, I appreciate it would help if we had a filled in TR1 now, such as in the Tessie case, because that was the declaration upon which the wife relied.
Yeah.
Conclusion, nemo dat, they weren't the beneficial owner, so they couldn't declare a trust. trust. My point is here, in lots of cases, sometimes things go wrong and they're rectified or whatever, but where there is an apparent declaration of trust, but signed by someone other than the transferee, for whatever reasons, that on the judge's construction would not have effect. And my lords and my lady, I say with all that in mind, the fund's position is that the judge's conclusion was, with great respect, wrong to conclude, and accordingly ground one should succeed. I'm in for when I said I would, which I suspect I will not be criticised. I will sit down unless there are any questions of me.
Any questions? No, thank you very much, Mr. Grant. Thank you.
Well, could,
Yes, Mr.
could the court just give me a moment to
course.
sort out my papers? The court has taken from what Mr. Grant has said how we divided up the issues. I don't want to repeat all the points that Mr. Grant has made, which I gratefully adopt. I just want to make 4 points supplemental to what Mr. Grant has said in relation to ground 1. The first point goes to the coherence of the judge's interpretation of section 53. Once one recognises, as Mr. Grant touched upon, that section 53(1)(b) is in contrast to subparagraphs A and C concerned with enforceability rather than validity. As will be familiar to the court, legislation is to be interpreted on the assumption that Parliament is pursuing a clear purpose in a coherent and principled manner, and not in such a manner as to give rise to impracticability, irrationality or unjustifiable inconvenience. We make those points in paragraph 23 of our main skeleton, citing passages relevant passages from Benyon, which I won't turn up. Now, as we will develop under ground 3, an orally declared trust of land which does not comply with section 53(1)(b) is a validly declared trust that is not enforceable. And just for ease of reference, could we just look at Professor Virgo? He succinctly makes the point. Its authorities at tab 164, Principles of Equity and Trust. Lord Justice Zacaroli, it's page 3271 PDF. And it is authorities tab 164, and if within that we could go to page 2, you'll see at the bottom of the page, the professor says, if expressed trusts of land are not proved by signed writing, the trust, and then we go over the page, the trust is unenforceable rather than void. In other words, the trust is valid, but it cannot be enforced by the beneficiary. So if the trustees wish to be bound by the trust, they can be, but they cannot be compelled to fulfil their trust obligations if they do not wish to do so. The function of the requirement of writing is merely to evidence the settlor's intention to declare the trust rather than being needed to create it. So the declaration of trust itself need not be in writing, and the written evidence need not be contemporaneous with the declaration of trust. I'll take the court in due course to Gardner and Rowe, which my Lord Chancellor mentioned in a little while. And we say that's a good illustration of the implications of the principle. The point of significance for present purposes is that given section 53(1)(b) goes to enforceability rather than validity, there's no reason why a properly authorised agent could not create a trust. Whatever section 53(1)(b) says about how it is manifested and proved, which need not be contemporaneous with the declaration itself. But it's as soon as one accepts that the Statute of Frauds and the Law of Property Act don't prevent an agent from validly declaring a trust over the property of the agent's principal, it becomes, with great respect, incoherent to suggest that the agent is barred from manifesting and proving it in writing for the purposes of the statute. One would expect ordinarily that the individual best placed to create a written record of the trust is the person who actually declared it in the first place. Indeed, my lords and lady, that incoherence emerges in our case because the judge had no difficulty in finding, on the one hand, that agents of NIOC had declared a trust over NIOC House, and yet, on the other hand, he held that those agents were not some person able to declare a trust for the purposes of Section 53(1)(b). Further, if one were going to limit the powers of agents in respect of declarations of trust over their principal's property, the logical way of doing so would be to control their ability to dispose of the principal's property in the first place, as is the case with Section 53(1)(a) and (c), not to limit their powers to evidence what was done. So that's our first point. The second point goes to a point which CGC takes against our suggested reading of 53(1)(b), and they rely on Section 40 of the LPA, which is the authorities tab 6, a PDF, my lord, is page 77. Now, my lords have this on screen. It's since been repealed, but it formerly provided, as you can see, that no action may be brought upon any contract for the sale or other disposition of land or any interest in land unless the agreement upon which such action is brought or some memorandum or note thereof is in writing and signed by the party to be charged or by some other person thereunto by him lawfully authorised. Now, CGC's argument is that this shows that the LPA always makes clear where signature by an agent is permitted, and they use it to reinforce their submission that the absence of such wording in 53(1)(b) shows that agents cannot sign documents for the purposes of that section. And my lords and my lady, there are two answers to this. First of all, CGC misunderstands our point in relation to Section 53(1)(b). We don't just rely upon the absence of any wording explicitly excluding signature by agents. We say that the words "some person who is able to declare" only make sense if they are read as including agents. Otherwise, the statute would refer to the person or the party in the same way that it does in Section 40, which we have on screen, or Section 53(1)(a) and Section 53(1)(c). In other words, properly interpreted, the statute has in fact provided that signature by agents is permitted in Section 53(1)(b) in line with the general common law. My lords and my lady, it's worth reflecting how peculiarly Section 40 and Section 53(1)(b) would have fitted together if an agent's signature did not satisfy 53(1)(b). On CGC's case, an agent could sign a binding contract to create a trust on behalf of his principal pursuant to Section 40. But the written agreement could not be adduced as evidence of the trust the agent had contracted to create for the purposes of Section 53(1)(b), even if the contract, on analysis, provided the best evidence of the trust in question. And that would be an odd mismatch in the formality requirements which we would say could not have been intended by the framers of the legislation. And in our respectful submission, that isn't coherent and could not have been what was intended. as Mr. Grant has submitted, there was no need for 53(1)(b) to make specific provision for agents, because in line with the general common law, an authorised agent is, in very simple terms, some person who is able to declare the trust. The third point concerns CGC's arguments by reference to the policy of section 53(1)(b). And the two bases they put forward. One is promoting a degree of caution on the part of the settlor, and secondly, certainty. It's a point they make in paragraph 50, their main skeleton. And we say that first, CGC is wrong about the cautionary aspect of this argument. Section 53(1)(b) in our submission does not have a strong cautionary function. It's well established that someone can create documents which manifest and prove a trust without in fact intending to do so. This is demonstrated by the case of Ong and Ping. Its authorities, I'm not going to turn it up now, I'm going to come back to this in detail in the context of point 1 of the respondent's notice. But very briefly, in that case, a letter from the settlor, Madam Lim, to her solicitors to the effect that she would like to cancel a trust was in fact held to be a document manifesting and proving the trust for the purposes of section 53(1)(b). And because section 53(1)(b) has an evidentiary function, it's not really directed at what a settlor has to do in our submission. Rather, it dictates what the beneficiary has to adduce in order to enforce the declared trust against its trustee. And that's a point I'm going to return to in a little more detail under ground 3. And we say that this somewhat diminishes the cautionary function of the provision. My Lord, on CGC's argument about section 53(1)(b) promoting certainty, Mr. Grant has already touched on this. It's apparent that the framers of 53(1)(b) and its statutory predecessors were not solely driven by a desire to maximise certainty. Had that been their only goal, they would have provided that a trust could only be declared in writing, signed by the settlor or by his agent authorising writing, in similar terms to subparagraphs A and C. They didn't do so, and we say that the consequence of the fact that they didn't is that they can be taken to have allowed more flexibility in the context of 53(1)(b) than in the context of subparagraphs A and C, even at the risk of greater uncertainty. And this has historically given rise to factual disputes, such as in Gardner and Rowe, as to whether there was a declaration of trust which predated the document said to be its manifestation and proof. And such disputes are nonetheless resolved with the tools at the court's disposal to ascertain as a fact if such a trust was genuinely declared, as happened in Gardner and Rowe. And against that backdrop, the pursuit of evidential certainty cannot be interpreted as being Parliament's sole consideration in the present context. That pursuit was, it would seem, balanced by a desire not overly to interfere with a person's right to declare a trust in respect of their property. So CGC can't say that its interpretation must be right because it's the most conducive to certainty or cautioning the prospective settlor against likely assuming trust obligations. Case law doesn't suggest that this was the sole principle in play. Lords and my lady, the fourth and final point responds to footnote 63 of my learned friend's skeleton, where they say that limited assistance can be derived from the case law on section 7 of the Statute of Frauds. As Mr. Grant mentioned briefly, there's a debate about the relevance of the learning on the predecessor wording in the 1677 statute. And CGC rely in seeking to diminish the relevance of the earlier authorities on grey and the IRC. That's at authorities bundle tab 55. It's PDF, page 972. And as Mr. Grant mentioned, this was a case which concerned Section 53(1)(c) of the 1925 Act. And in summary, it was argued that the words disposition of an equitable interest or trust in that provision should be given the same meaning as all grants and assignments of any trust or confidence in what was Section 9 of the Statute of Frauds. And the House of Lords naturally rejected that submission, finding that the change of words connoted a change of meaning. And if we look at page 17 in this tab, page 17 of the authority as well. It's page 988. One can see that in Lord Radcliffe's speech on this page, where you can see at the bottom of the page, he talks about the link between Section 9 and 53(1)(c) of the 1925 Act being broken effectively by the change in language. And to similar effect, page 15, page 13, in Lord Symonds, Viscount Symonds' speech, see in the second paragraph, he talks about the change in language in 53(1)(c), and then 2/3 of the way down, if the Law of Property Act 1925 is a typical consolidating act, the question would be whether change, whether
well, it's the point that I'd already made to Mr. Grant, actually, isn't it? That you trace it back to the 1922 Act. That was the act which actually changed the law.
Yes.
And that's the point he's making. The 22 Act changed the law, including as regards to statute of frauds. And the 25 Act was a consolidating statute, but it was consolidating the law as it had already been changed.
Indeed. Gray turned on the fact that the amending Act of 1924, which the 1925 Act consolidated, had itself introduced a change to the language of 53(1)(c), and it was that which broke the link, which is the point that Lord Radcliffe made at page 17. But in our submission, there is no such break in the link when it comes to 53(1)(b). We're subject to one important point that I will mention in a moment, which is on analysis in our favour. The language remains not just similar, but identical in critical respects.
Yeah.
And if we pick up authorities tab 145, (2919) is a PDF, I'm told. And you'll see an extract behind this tab from Burroughs' English Private Law. And if we go to the second page, bottom of the page, one can see just towards the bottom, the learned editors talk about the statutory rule with regard to land is contained in the LPA 1925, set out the statute, and then says this is a reenactment of Section 7, the Statute of Frauds. And then they talk about, if we go over the page, the problem it was designed to meet. And if we could just read to the end of that paragraph. And I'll come back to this in the context under ground 3 of who may rely on non-compliance with the Statute of Frauds and the 1925 Act. And I don't want to labour the point, but if one looks at the footnotes to passages in texts relied on by my learned friends, they are replete with references to pre-1924 case law on Section 53(1)(b) and Section 7 of the Statute of Frauds. Just by way of example, tab 167, Bulgarian Wade, authorities 167. Look at page 3. This tab, it's my Lord Justice Zacaroli's, it's 3330 in the PDF. A very short point, but one can see that where the learned editors are talking about the requirements of the 1925 Act, one sees regular citation of the case law under the Statute of Frauds if one just glances at the bottom of the page. I don't want to spend time turning it up, but similar references can be found in, for example, Lewin at paragraphs 3012 to 3017. We won't turn it up, it's Authorities tab 163, page 4, PDF page 3260. And the court will have seen that the judge himself referred to pre-1924 case law when considering the effect of Section 53(1)(b) in paragraph 208 of his judgment, which you don't need to turn up. The effect of any changes to the statutory wording of Section 7 to the the statutory wording of Section 7 of the Statute of Frauds to the pre-1924 case law entirely depends upon the character of those changes. Now, you've been taken, I think, to the text of Section 7. We could just take this up again behind Authorities tab 1, page 12, page 20 of the PDF. You can see redlined Section 7. And one can see at a glance that once one gets through the opening words, its terms are very similar to Section 53(1)(b). The only remarkable change is the deletion of the words "or else they shall be utterly void and of none effect," which rather suggests that the 1920s Parliament intended to confirm the principles firmly established in case law subsequent to the 1677 Act, to the effect that this provision is concerned with the enforceability rather than the validity of trusts, a point made by Professor Udan at footnote 77 of his article, which I think Mr. Grant went to. It's at, just to remind the court, it's at Authorities tab 133, page 16, PDF 2782. You see at footnote 77 at the bottom of the page, the modern English provision, section 53(1)(b), does not contain any provision that non-compliance will make the trust utterly void of no effect. Indeed, it does not express any sanction for non-compliance. Consequently, it be taken to confirm the interpretation of section 7 by the cases. And then, just on the same point, Professor Swadling, an article on Rochefoucauld and Bousted, tab 1, Authorities tab 140. Page 10. I'm afraid I don't have the PDF reference. It should be on the screen, hopefully. Page 2883.
No.
2891, I'm told, is the relevant reference. And if we look at page 11, just towards the top of the page, you'll see that Professor Swadling says, despite speaking of a declaration of trust of land not manifested and proved by writing, being utterly void and of none effect, words which incidentally no longer appear in the Law of Property Act 1925, section 53(1)(b. It's well established that section 7 was not a rule of validity but of evidence. So we don't accept that cases on section 7 of the Statute of Frauds are of no assistance to the court in construing section 53(1)(b. To the contrary, where Parliament has retained the wording used in section 7 or amended it to confirm the existing case law, those cases are of very substantial assistance. And my lords and my lady, for that reason, for those reasons and the reasons more fully given by Mr. Grant, we say that as ground 1 of our appeal, the judge was wrong to find that a document signed by an agent does not suffice for the purposes of section 53(1)(b), and that given the judge did find that there were declarations of trust signed by agents on behalf of NIOC, if it were not for that error, he would have found that NIOC House was held on an enforceable trust for the fund, with the consequence of section 423, the section 423 order should, in our respectful submission, be set aside.
At a convenient moment. 2 o'clock then, please.